answer that, I'd like just to explain why I say I know what I'm talking about within arbitration. And the reason I'm talking to you about it today is because, as well as being a solicitor and representing people within the arbitration process, I am also a qualified arbitrator. And so I'm able to talk with authority about the arbitration process itself. There's a real problem in the family courts at the moment. The delays are long and they're only growing. If you deal with money within a divorce process and you ask a judge to make a decision for you to decide how the money should be divided between you in a divorce, you're looking at least a year, possibly 84 weeks before you get to that final hearing. And the problem is, in all that time, at the beginning of the process, you deal with your finances. So you put together a document called a Form E, which explains your full financial situation. By the time you get to the first court hearing, the second court hearing, it's out of date, so it needs updating. And so you're adding to the costs all the time you're having to update because of the delays in the court. And in all that time, you and your partner don't have a decision, and that puts real pressure on an already very difficult relationship. And so the delays in themselves can cause more arguments between the family and actually make the situation worse. Also, the press are now allowed into some court hearings to do with money and divorce. And that can itself cause worry for people. It's very rare, but it can happen. The other big change that we had in the spring this year was that the courts have now been told they must tell people they should try non-court dispute resolution, which is sorting out the case without a judge's involvement. And if they don't, the courts can actually postpone the hearings to encourage them to try that non-court dispute resolution. So you can wait months for a court hearing and then find it's postponed because you haven't tried something else. Arbitration is a method of non-court dispute resolution. So what is it? Well, the way it works is that you and your partner would appoint a fair and impartial family arbitrator to resolve your dispute. There are a list of arbitrators on the Institute of Family Law Arbitrators website, and the arbitrator will provide the decision for you. They have, in terms of making the decision, they have broadly similar powers to district judges, and their decision is as binding as a district judge's decision and can be appealed in the same way as a district judge's decision. The arbitrator will make the decision after hearing each of your points of view and what you have to say about the situation, and their job is to act fairly and impartially in reaching their decision. They will provide an arbitration award that will explain in great detail why they've made the decision that they have and how they've applied the law for you. They're flexible, so you can use the traditional court method. You can have a meeting where you decide what evidence is needed, and that if you can't agree, the arbitrator will decide for you. You can then have a negotiation hearing away from the arbitrator using an independent person to help you negotiate, which is what you do at court. And then you can go to a full final hearing where you give evidence. You sit in the witness box in the same way as you would in front of a district judge at court. But it doesn't have to be done that way. You can decide with the arbitrator that actually evidence isn't needed. It's clear on the paperwork what's going on. And so you can ask to go to a hearing because you want to see the arbitrator and listen to what's said, but you can ask for it to be done on submissions, which basically means that your lawyers will explain the situation to the arbitrator without you having to go in the witness box and give evidence. And in some cases, if it's appropriate, you can even say to the arbitrator, I don't want to see you. We're going to put all the paperwork before you, and can you decide, give us the decision on the papers only and give us an award based on what we've written for you. You don't have to use arbitration to decide the whole thing. It might be that you've agreed what's going to happen with your house and your savings, but you can't agree what happens with the pension. And you can bind the arbitrator into your agreement about the house and the savings and just give them the power to deal with the pensions. And their decision will be binding on all three issues. If you go to court, you can explain to the court what you've agreed on the house and the savings, but the judge isn't bound by that partial agreement. You can also combine arbitration with other methods. So quite a lot of people have heard of mediation, where you go along and a third party helps you to negotiate with your partner. But some people are concerned about mediation because they're concerned that perhaps they'll try that process. It might take 3 months, 6 months. If it doesn't work, they're then at the back of the queue if they go to court. If they think the other party is actually causing problems and trying to cause delay, they're going to be worried about trying the mediation. But what some people do is they sign up for arbitration and tell the arbitrator that they will do mediation. The arbitrator can help decide what evidence is needed: bank statements, pay slips, P60s, whether the house should be valued, whether we need to bring in experts to help with the value of assets. And that paperwork is taken to the mediator. If the mediator is able to help make a decision, great, we're done. If not, a partial decision could be taken back to the arbitrator for them to decide the rest of it. Or if there's no agreement at all, it can go back to the arbitrator again, knowing that you've tried to agree things directly. And the beauty of it is that the same paperwork that the arbitrator told you to get at the beginning will go to the mediator and then come back to the arbitrator. It's a bit like a travelling bundle. It can pass between all the experts. You haven't got to do that, but there's all these options open to you. It's very flexible in the way that you use it. The benefits for you would be speed. You can, if you've already got your paperwork set up in advance, you can ask the arbitrator to go straight to a final decision. And certainly that can be done within months. I've known clients, not often, but it's happened, wait a year to hear when their court hearing is going to be. You work around your arbitrator's diary. And if you've got lawyers involved, you work around the 3 diaries. It can be done on simple phone calls or emails, giving dates to avoid, and set up very quickly. I've seen it done, as I say, within about 4 months. So the benefits of the speed, the benefits of the agility, having all these different processes that your lawyers can help steer you through, can be as simple or as complicated as you want it to be. Another benefit is the choice of who's going to make the decision for you. When you go to court, you don't know what judge you're going to get. You might get a deputy who might be brilliant, but you might get a deputy who deals with personal injury in their other role, making a decision about your divorce. So you can decide which arbitrator you want to use, or you can say, right, between us, we like these 3 arbitrators, and you can go to the Institute of Financial of Family Arbitrators, and say to them, these are the 3 we like the look of, you decide which one we go to. But you know the person making that decision for you is an expert. And that is really important. You may say to me, look, Emma, you're gonna spell the virtues of arbitration. It's what you do. Yes, it is, but I chose to do it because I felt that it was needed.